Working on. We're gonna stop that.
Okay.
Yeah, thank you. Denise, here's. Thank you. All right, Tony, call the case, please.
Jason Van Dyke.
All right, will the attorneys take their names, please?
Morning, Judge Joe McMahon for the people of the state of Illinois.
Joseph Cullen on behalf of the state.
Jody Gleason on behalf of the state.
Carolyn Hyde Ross for the state.
Dan Wiley for the state.
Good morning, Dan Herbert on behalf of Jason McMahon.
Tammy Went from Mr. Van Dyke.
Randy Roof Company, Jason Van Dyke.
Elizabeth Bowman on behalf of Jason Van Dyke.
All right, do we have any other attorneys or individuals that are here?
They're out in the hall.
Yeah. Thanks. All right, we don't need everybody up here, so whoever's going to argue these or present these things, Mr. Van Dyke can't see. All right, excuse me. I couldn't have this. All right, let them up here. All right, move outside. All right, will you state your name and your purpose here today?
Morning, Your Honor. My name is Renee Popovitz, P-O-P-O-V as in Victor, I-T-S. I'm counsel for TASK, Just Treatment Alternatives for Safe Communities. And I have with me William Salas, TASK, and General Counsel Michelle Walker. We are here because we received a subpoena for information, and we have sought a motion to quash and to have a hearing.
When was the return date on the subpoena?
What was the return date on the subpoena? It was actually.
In this courtroom, we don't repeat the questions because it puts me back to trauma when I was in grammar school because the nun would knock me and my desk on the floor because they knew we were stalling. All right, what's the return date on the subpoena?
It was September 5th.
All right, what's today's date?
Today is.
After September 5th. How come you didn't come in on a motion to quash further?
Because the information was recently sent to me.
You didn't get the subpoena until September 5th? I mean, you didn't get it before that?
No, I didn't.
And okay, that's me. All right. Did your office or task receive that? All right, you're the one issued the subpoena, is that correct?
Yes.
All right, give me some information about what's going on here. When did you have the subpoena served? I'm sorry, we're gonna take a recess. We're doing this again. Get prepared. We'll call it when you're ready, all right?
You guys were.
All right, call the case.
Recalling Jason Van Dyke.
First of all, before we go forward, then, all right, we can turn over the information. Whoever, who's bringing the speaking attorney?
I'm bringing a motion on Renee Popovitz, counsel for tax.
Wait, come on, I'm not seeing now, you just said it 5 minutes ago. All right, so now here's the thing is that, so you have the documentation, is that correct? And you're making a motion to quash the subpoena?
That's
All right. Do you have the documentation in your hands? What was the return date on the subpoena then?
August 29th.
August 29th. And now you're just,
And that's what we got. And that's the day we got it.
you got what?
I got the document right here.
All right, so who's objecting to it?
We are.
How? You've turned them over.
We turned it over for an in-camera proceeding to determine whether the cost exists to action.
All right, give me your, all right, let's go on to motion then. All right, what's your motion?
Our motion is that the records should not be disclosed because they're protected under several privacy laws.
Stop that, start articulating the privacy laws you're talking about. We'll do those one at a time. Mr. Ruger, you prepared to make a presentation as council's going to elicit and present the reason why she doesn't want this material turned over.
Yes.
All right, go ahead.
Your Honor, there are three primary reasons why this information is protected, because it's from a juvenile court record, which is under seal.
Is that statutory? 1898 is when Illinois first enacted the first juvenile law in the country. All right, so that's statutory. Go ahead.
The second.
Well, now, what is the purpose of the Juvenile Act and who does it protect?
was the purpose of the Juvenile Act to protect.
Okay, what if the juvenile has passed? No, listen, I really love this because you're being very candid. I appreciate this. So kind of want to, all right, good. All right, so we'll move on to the next one.
The second one, which is actually the most important, is the federal confidentiality statute regulations 42 USC.
Is that HIPAA?
No, it's stringent regulation.
Okay.
It covers the confidentiality of drug and alcohol treatments, including drug testing. And that is 42 USC 290DD-2, sorry, to CFR part 2. Sorry, 42 USC 290DD-2 and 42 CFR part 2.
Mr. Ruger?
Just, I understand the law, but I'm saying back to the person is deceased
No, why is this an exception?
because the person.
What does the law state that if you understand it? No, what
Because I
basically?
understand it that they can't be produced unless there's an exceptional reason to be produced.
That is correct, but the federal regulations protect patient records, oral and written, whether they're former current patient or whether they're alive. There's a section that has a specific requirement on how we can release information of deceased patients. That would be with the consent of family or administrator or an appropriate court.
Mhm.
So, Your Honor, if you were to determine that it's appropriate to release information under 42 CFR 2.64, you would need to determine that good process exists. There's a two-part test to determine whether good process exists. The first is that other ways of obtaining the information are not available or not effective. And second, the public interest and need for the disclosure outweigh the potential injury to the patient or physician-patient relationship or treatment services. In our motion, we outlined those requirements. In the first prong of that test, the other ways of obtaining the information are not available, not effective. As a met, it is our understanding that that's when this information is ready to go through the witness testimony.
All right, Mr. Ruger.
Yes, Judge, I just have an issue with it's in the public interest and the need for disclosure outweighs.
Would you address what Council has stated? No, yeah, she said that you have gotten this information through other means. Have you, haven't you?
Well, I don't know if we got the same information to other means. There's a
Is that
difference.
your statement?
Yes,
And you don't know what information, have you compared, how would you get information
Because-
from task? without them,
I've seen the records
all right,
that I want him to testify to.
but then you should know whether you got that same information that you have in your hands from the records,
We have
from
not
other
got-
sources.
We have not got the same information in this court. No.
What means have you, excuse me, you know, Mr. Saracen now, because of your distraction to Mr. Ruker at this time, he's not paying attention. Right? I mean, what means have you, all right, answer the question about what other means you have exhausted to get the other information.
But other means we've exhausted.
As I told counsel, don't repeat the question.
I think the only way we can get the information is through.
Well, then state the reasons for your thought process, so we all can
That's the
understand.
only way we can get the information is through task. We couldn't get it through any other source.
You want to rephrase and say TAS is the only one that has this information,
I'll rephrase it that way, yes.
but say it as an attorney and say it as an officer of this court. Is that your belief?
That's my belief. The task is the only place we can get information.
All right, moving on to the next prong of this.
Well,
Say it again,
The
please, counsel.
second prong of the test is the public interest in the need for
Counsel, speak up a
disclosure.
little bit. You're on TV.
The second prong of the test is the public interest and the need for disclosure outweigh the potential injury to the patient, physician-patient relationship, and the treatment services.
Where is the patient? All right, you answer that.
well, the patient's dead.
All right.
Deceased. And the public interest is much more important right now than a deceased. For him to get a fair trial right now is more important than any records the deceased may have.
This will certainly not damage the patient-physician relationship. Is that agree?
The actual physician. This
Well,
patient-
I'm listening and I'm paying attention to what you're saying. So it certainly will not, in this situation, damage the patient-physician relationship. Is that correct?
That's correct, but there's a broader interest to the treatment relationship. And the whole reason why this federal law was enacted. is-
No. I'm just, listen, you know, everybody's starting to, just like pouring a glass of water on a table. We have to have some boundaries. You said one of the things was attorney-client, patient, doctor, or physician relationship. That doesn't exist anymore. So forget about the other stuff, all right? Now, the next thing is, would it be harmful to the patient? It can't be harmful to the patient if the patient has passed, right, which is tragic. All right, the next thing is about the public interest. First of all, we have to, and it is a balancing, and I agree with you. And I'll probably state it a little bit better than stated by counsel. It is a balancing test. Mr. Van Dyke is charged with first-degree murder, which is one of the highest charges in Illinois. I think it even supersedes treason to the state. So that is one of the factors of looking at, is there overriding public interest? You know, and everybody else knows, the public interest in transparency in this case. It's just been, if you turn around and look at media's here, and their coverage has been outstanding. So the public interest of the charge demands that I have to order you to turn over that material.
Rather, if you order us to turn it over, there's additional requirements in the federal regulations that we need to comply with in order to turn it over. Including Mr. Sales's testimony, we need an order that limits the disclosure of the information that's necessary to fulfill the order. We have to specify that we can turn over.
Have you looked at my decorum orders?
Pardon me?
Have you looked at the decorum orders in this case? They cover it all. Right? Forget about the federal regulation. These are officers of the court here as yourself. So incorporated in the decorum order, besides restrictions on what the attorneys can do, is the code of professional responsibility, which covers exactly. No, I do admire your tenacity. Your presentation has been outstanding. But in this case, these are officers of the court. If you see them violating anything, you come back in, we'll get them. All right? But I'm ordering you to turn it over. And certainly I'll discuss, I'm the gatekeeper here as far as evidence is concerned. So they certainly won't go. And again, these are honorable people. They're not going to fire people. But I understand your position and I really, appreciate it. You're really defending your client. So I want to compliment you as an officer.
Thank you, Your Honor. I have a copy of the court order.
Now, let me explain another thing about criminal courts, all right? When I order it, the transcript is the order. But if you're on the appellate court, you can order me to sign that order. If you're on the Supreme Court, you can order me to sign it. Until that happens, which it probably should, I'm not going to do it. But it is an order. You're going to be covered like this. I am ordering you in open court to turn over this material. And I want to thank you for your presentation and your awareness of the law.
Your Honor, we need a decision on the media as my client is.
Speak up. If it's a decision on the media,
On the media. The
Yes.
media coverage. My client has completed the form that the defense attorney had sent.
okay,
us.
what we'll do right now, and I give you a common courtesy, we've been given all the witnesses. We'll go in chambers and we'll have that petition. Okay?
But I think just, one issue on that. Now that you've resolved the issue of turning the records over, I have an objection as to their relevance and admissibility of the proceedings. So we would likely request that during
I
the
think-
issues conference.
Yes, please. All right, that would be outstanding. All right. Okay, we're gonna take a short recess and we're gonna resolve the issue about extended media coverage and also whether this information is material or not. Contact.
Judge, we attempted to get in some training videos to one of our witnesses. The training videos were disclosed months ago as far as what videos we would be using. Last night, we made the decision to show a portion of those videos instead of the entire video, and sent that to the prosecutor, and the court ruled that we would not be allowed to show the video.
Mr. McMahon?
Because what we received last night was a series of videos that lasted several hours, or well in excess of 1 hour. I don't know the total time, but one of the 6 videos in and of itself was more than 60 minutes. We objected to the use of those videos. We're not objecting to the testimony of the witness that they disclosed, but we're objecting to the use of those videos in front of the jury because of the late disclosure and because of our inability to cross-examine essentially the contents and the relevance of the substance of the videos. We objected to that, sustained our objection. We ruled that those videos are not properly admissible for the jury this morning.
All right, as presented in chambers, there was Ms. Fleming said that one of the videos was tendered about 3 weeks ago. The other one was tendered about a month ago, not months. Right? I can read it back.
No, Judge, I didn't mean to insinuate.
No, I understand. There was a lot of,
Titles
excuse me, I'm defending you. There was a lot of information presented at that time, so I know this is nothing intentional. It's just that there was a tremendous amount of information being discussed back there. So let the record be very clear that this was not an intentional misrepresentation. All right. The fact is, these were certain excerpts. There was additional matters. This person was a training officer when Mr. Van Dyke was going through the academy. Is that correct?
That's correct.
He will not be able to personally say that I remember Jason Van Dyke in my class. Is that correct?
That is correct.
And we don't have attendance sheets showing that he was there that day that training was presented. That's another reason. The other reason, as been stated, this is case has been going on for several years. These tapes or videos were in existence since 2000. They're the same ones. So the lateness of the event and just being tendered the night before the witness was going to be presenting this information. That's why I'm going to deny, along with the reasons I gave in chambers, your request to play these videos. The other thing is, as Mr. McMahon has articulated, your expert witness will certainly be able to testify to everything that he presented at those training events. All right. We had another one concerning.
Yes,
right.
Mr. Rudolph Bennett was disclosed as a witness months ago, and today the state asked for an offer of proof. I provided the offer of proof, which was essentially that Mr. Rudolph Bennett was the Juan McDonald's ECFS worker. He was assigned to Juan McDonald's case up until death of Juan McDonald, and it was our intention to get into testimony from Rudolph Bennett about the fact that there was an investigation pending regarding the Juan McDonald's ability to live with his foster parent, who was his uncle. And depending on the results of that investigation, the Juan McDonald may have been sent back to the DOC. So we wanted to get into that information to show that on the night that Juan McDonald died, that Juan McDonald was out of control and was simply at the end of his rope for many reasons, one of which included that he thought he was going back to the DOC. And the court ruled that testimony will be not allowed.
Mr. McMahon.
Judge, we objected to that testimony because on a couple of reasons. The proposed testimony of Mr. Bennett is neither admissible under Lynch nor is he qualified to give opinions about Laquan's mental state on or near October 20th, 2014. The other reason we objected, Judge, is because of this alleged or supposed investigation of a relative of Laquan McDonald had absolutely nothing to do, and there's no causal connection between that investigation, if there was an investigation, or what the focus of that investigation might have been. There's no connection between any investigation and Laquan McDonald's activities on October 20th or the days leading up to October 20th. So we objected to that relevance of that testimony as well, and you sustained that objection.
All right, and my findings were, the investigation that was presented or offered in the offer of proof was an investigation of the uncle, whether he was a fit adult to be the foster parent or be the guardian for Laquan McDonald, and whether the premises that he was living at the time, were proper for a minor. That has nothing to do with this case. So that's the reason why I did not allow that proffer. Plus, we don't know the qualifications of this person from Department of Family and Children's Services as far as education, therapeutic training in those areas. We had another motion.
Yes, we had a witness from task, whose name is escaping me right now.
Sarah.
Mr. Salas. Mr. Salas, we reported that he would testify to the positive urine drops of Laquan McDonald from,
And they were positive.
positive, one was for marijuana and cocaine, one was for PCP. Two separate drops done at juvenile court. At least one of the incidents was testified to by our lynch witnesses, I believe, and the court ruled that his testimony would not be allowed.
That's correct, Judge. We objected that the supposed test results, there was no proper foundation. Mr. Salas is not a qualified witness that can lay that foundation, that can establish a chain of custody. But beyond that, what we argued is that test results or allegations of generalized drug use are not admissible under Lynch or the cases that we decided. For the one instance where there was crossover, the lab results are hearsay under the Melendez versus Diaz versus Massachusetts, which is a United States Supreme Court decision that says lab results are essentially testimonial in nature, and certified lab result is not admissible without proper chain of custody and foundation.
And then, exactly for interrupting, in the Massachusetts case, what the Massachusetts prosecutor was doing was getting a certified certificate by a forensic chemist stating that the substance that they had examined and the chain of custody was a controlled substance. And my understanding also is the United States Supreme Court said this is hearsay. It cannot be admitted into evidence.
That's correct. So we objected based on the nature of the evidence would be hearsay, and that Mr. Salas cannot lay a proper foundation to admit that result.
Just one final point.
Sure, go ahead.
One part I left out was that we had a signed affidavit from Mr. Salas that clearly shows that the lab results are a business record kept in the normal course of business. So it is our position that that those results should absolutely come in based upon the fact that it's a business record. It's properly admissible.
Massachusetts seems to be the focus of our attention today. There's a great case from Massachusetts which said that hearsay is not allowed to ride in on the throne of a business record. So it still would be hearsay. Mr. Salas is not qualified as a forensic chemist, so anything he'd be testifying to would be something that someone told him or something that he read. So those are the reasons why he would not be able to testify. But your motion for those records were in opposition to the motion to quash the subpoena and express the documents. You were successful in that. All right, so that's everything, right?
So, Judge, on that point, does that mean that we can enter the lab results as an exhibit? Since the
How are you going to get them in? Don't be listening to him. Okay, all right, good.
just checking.
All right, thank you. No, that's good. Thank you. Will you bring our wonderful people out?
All right, for the jury.
Okay, will everybody please be seated? Good morning, ladies and gentlemen. Good morning. Good to see you in a good state of mental fitness and also apparently good humor too, so that's outstanding. We're gonna do something different today. All right, you all know the questions. Have anybody discussed this case with you, or has anybody discussed this case in your presence? So we have been going through this. What I'm gonna do, because you've been so outstanding, is there, we'll just do it in a group right now. Did anybody discuss this case or have anybody discuss it in their presence? Please raise their hand. Thank you. Nobody has raised their hand, so we're very efficient today. All right, defense, call your next witness, please.
Yes, Judge. At this time, the defense will call Ms. Rebecca Patterson.
Denise, did you get a list of witnesses? Okay, good. Excuse me.
Watch your step, remain standing, and then just wait.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give before this honorable court and jury shall be true, the whole truth, nothing but the truth, so help you God? Thank you.
Have a seat, ma'am. The seat's adjustable, the microphone's live, so pull your chair up to the microphone, speak into the microphone, and everybody will be able to hear your testimony and be greatly appreciated. So thank you.
Thank you.
Proceed.
Thank you. Good morning, ma'am. How are you?
I'm fine.
Thank you for coming in. You're here pursuant to subpoena, is that correct?
Yes.
And would you please introduce yourself and spell your first and last name, please?
Yvette Patterson, Y-V-E-T-T-E, Patterson, P-A-T-T-E-R-S-O-N.
Okay. And Ms. Patterson, I want to direct your attention to October 20th, 2014 at approximately 2 o'clock in the morning. Did you have an occasion to contact the Chicago Police Department via 911 that day?
Yes, I did.
And can you tell ladies and gentlemen of the jury why it is that you contacted 911?
Because I was coming home from a party, and I seen a young man sitting on the stairs. When I put into my bag, my lights automatically pop on. So I seen him sitting. He walked over. He jumped up because I believe he seen the light, so he jumped up. And he walked. He didn't come close to the car, but he walked over and he was like, "Can I see your car?" And I'm like, "What do you want with my car?" And he was like, "I just want to use it. I'm gonna bring it right back." So me and him just laughing and talking. We talk. So I'm like, "No, you can't use my car." I said, "I don't even let my son drive my car." So no, you can't use the car. So he said, "Okay," and he started laughing. And we just sit there talk. I asked him, "Who are you?" And he was like, "I live upstairs." And I said, "No, you don't. I've never seen you before." And he said, "Yes, I do." So I ended up calling the police. I called the police for the simple fact because I wanted to go in the house.
Okay, you wanted to go inside your house.
Right.
And this individual said he lived above?
The next building over from me.
Okay.
That's where he said he lived.
And you didn't believe that to be truthful?
No, I didn't,
Okay.
because I'd never seen him. I know his kinfolks, but I never seen his face.
Okay. And you said you wanted to get into the house. Were you fearful to go into the house with this individual there?
I wasn't fear at all. I wasn't fear. It was just the fact that, I wanted to go in and I wanted to be sure that I was gonna be okay getting out of my car going into the house. He didn't fear me because of the conversation we had. He seemed like, he was a nice young guy or whatever. But, still, I wanted to be protected to go in my house.
Okay, and that's why you called 911.
Exactly.
Do you remember this individual saying anything else to you other than what you've just testified to?
No, he didn't say anything else to me until he was with the police.
Okay. I'm going to direct your attention to on February 25th, 2015.
Mhm.
You spoke to the FBI, is that correct?
Correct.
And on that date and time, they asked you about what this individual said to you, correct?
Correct.
And you told the FBI that the person said, "Who the F-U-C-K, do you know that lives here?"
That's how he addressed me.
Okay. And that was part of the reason why you called 911 as well?
Well, I called 911, like I say, I called 911 because I wanted to go in my household safe. So
Okay.
that's why I called 911. I never seen a young man before. No one never is in the back of my house when I come in. I have came in 3, 4 o'clock in the morning, no one is never out there. So I see someone out there that, yes, I'm gonna call 911 because I want to get out of my car safe and I want to walk into my household safe.
Okay. And that's why you called the police, to be
Exactly.
protected, correct?
Yes.
Okay. And if I can show what I've marked as defense exhibit 17, I've showed to the state. May I approach the witness? Sure. Ma'am, I'll represent that this is it's called an event query from the Chicago Police Department.
Mhm.
My question is, you don't have to read out the number if you don't want, but I'm pointing here to a phone number that indicates that that is the number that called 911 to report that incident. My question is, do you recognize that phone number?
That's my phone number.
Okay, it's still your phone number today?
Yes.
Okay. And the address on here, and again, you don't have to give the address out.
All right, listen, just so it's clear, the phone number nor the address will be published. Move on. But you can verify the numbers.
Do you still live at the address in which
Yes.
the address of the occurrence is indicated there?
Yes.
Okay. And that's the west side of Chicago, is that correct?
Yes.
Okay. And in the remarks comment for the event query, and tell me if this is what you remember telling the 911 caller.
Objection, Judge. This is hearsay. Undocumented.
It's a foundation.
Do you remember telling the 911 dispatcher that you were parking your car behind a building and a male black with dreads with a black hoodie walked up to your car and asked you who she was looking for? The individual is now standing on Campbell by the school, and that you were afraid to get out of your car and go into the building. Does that sound like what you told?
Yes.
Okay. And did you later find out who that individual was that you called 911 to report?
Yes, when I woke up, I seen the news and I seen his picture on the news.
Okay. And who was that person?
Laquan.
Okay. Laquan McDonald?
Yes.
Okay. I have nothing further. Thank you again.
You're welcome.
Cross-examination second.
Ma'am, you knew LeBron's relatives who lived near you, was that correct?
Yes.
And did they live in that next building?
Yes, they did.
No further question, Your Honor.
Anything else? Nothing. Thank you very much.
You're welcome. You too.
Could I have the attorneys over here for scheduling, please? Thank you. Defense, call your next witness, please.
That's called Dr. James O'Donnell.
Watch your step, remain standing and just face the floor.
You solemnly swear or affirm that the testimony you're about to give before this honorable court and jury shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Doctor, have a seat, please. Thank you. The chair is adjustable, the microphone's live, so if you could pull your chair up to the microphone a little bit more, please. There you go. All right, and speak into the microphone. Everybody will be able to hear your testimony, and it would be greatly appreciated. So thank you. Proceed, Ms. Webb.
Thank you, Judge. Good morning.
Morning.
Could you please introduce yourself to the jury?
Good morning. I'm James Thomas O'Donnell.
Doctor, or what is your occupation?
I'm a pharmacologist, pharmacist, and nutritionist.
What is a pharmacologist?
A pharmacologist is a scientist or a clinician who is involved in the discovery, development, analysis, testing, or evaluation of the effects of drugs on humans and animals.
And it involves pharmacology.
Pharmacology, or pharmacology from the Greek meaning drug, study of drugs.
And what is clinical pharmacology?
Well, clinical pharmacology is the last part. Most of the early part is in a laboratory, in test tubes or tissue cultures or in animals. Clinical pharmacology, anything where you use the word clinical, it means a human being. That's where we take the drug and test them in humans to see if they do what is shown in animals. And then post-market, post-approval, a clinical pharmacologist consults with physicians in selection and evaluation of the effects of drugs in patients.
Okay. Do you own your own business?
I do.
What is the name of that business?
My business name is Pharma Consultant Incorporated.
And what kind of service does your company provide?
For all intents and purposes, it's any services that I offer professionally. For instance, when I'm paid for my work at Rush, they pay my company. When I consult in litigation, civil lawsuit, or criminal matter involving drugs, my company is paid. When I get paid royalties for my books, it's paid to my company. So I do litigation consulting, academic teaching, government consulting, editing and publishing and public speaking. And from time to time, for many years, I worked in pharmacies as a pharmacist. Just haven't done that in the last 8 years.
Okay, so you mentioned you also teach at Rush.
I'm on faculty at Rush. I'm an associate professor. I've been on faculty since 1979. I have teaching duties now, and I also have service responsibilities where I work on one of the research committees, and I'm also involved in the admissions committee for the medical college.
So what do you teach at Rush?
Most of my teaching is pharmacology, how drugs work, how drugs are tested, how drugs are evaluated. I teach international drug regulations. I teach ethics in health research. And I used to teach toxicology principles.
Okay, can you give the jury a brief description of your education?
Yes, I have 3 college degrees, a bachelor's, a master's, and a doctorate. A bachelor's in pharmacy from the University of Illinois, a master's degree in nutrition from Rush University, and a doctor of pharmacy from the University of Michigan.
And what do you have to do to become a pharmacologist?
There are a couple different paths. What I did is I became a pharmacist first, and I took an additional degree in pharmacology, in pharmacy, the doctor of pharmacy, and I did an additional year of training in a residency. And then had employed as a pharmacist, first at County Hospital and then at Presbyterian St. Luke's, now Rush. And I was involved in clinical monitoring of drug therapy in patients. I was involved in teaching a few different universities. I started publishing, became more and more involved in actual drug evaluation. I applied for the membership in the American College of Clinical Pharmacology, was accepted. I also applied to take a certification examination with the American Board of Clinical Pharmacology, which required extensive documentation of background and research, scholarly activity, publications, and recommendations. And fortunately, when I took the examination, I passed the examination, which was in about 26 years ago. So now, aside from that's a fellow status in the American College of Clinical Pharmacology, diplomat of the American Board of Clinical Pharmacology. My academic rank is associate professor of pharmacology. And for several years, as a result of that credential, that background, I was also served as a course director for medical pharmacology. Others go and take degrees in pharmacology and then do research. I had a little bit different pattern. Pharmacology is a little bit different from many medical disciplines in that it draws from a broad, wide arena of different training and experience bases. But the common theme is, how do drugs work? How are they used? How do they cause harm? How can we avoid harm?
Thank you. So when you say American Board of Pharmacology, does that mean you're board certified?
Yes.
Okay, thank you. And you're licensed in Illinois?
I'm a licensed pharmacist in Illinois, yes.
And how do you become a licensed pharmacist?
50 years ago, you had to go to college and spend 5 years studying chemistry and pharmacology and pharmacognosy and other biological studies, spend 2,000 hours in vacation time working as an apprentice pharmacist, then take a board examination, which I did, and I was licensed in August of 1969.
And have you previously been on staff or affiliated with any academic or medical organizations that you did not mention already? I know you said Cook County Hospital, but any others?
I've been on faculty at the University of Illinois College of Pharmacy in 2 different periods, one in the 70s and one in the from 2007 to 2014. Faculty of the University of Illinois College of Medicine in Rockford, from 2000 to 2014. Faculty of the Northern Illinois University for 2 years in the 1980s when I taught pharmacology in their nutrition program. And I also was on faculty at Purdue University as what's called a preceptor, where they sent graduate students to learn how to be hospital pharmacists. When I was at Cook County Hospital, now known as Stroger.
Okay. Can you tell Jerry the difference between pharmacology and pharmacy?
Well, pharmacy includes the study of pharmacology, but also has additional training and responsibilities for taking a chemical that's proven to be a drug, proven to have drug actions, and actually making a medicine. So like taking a powder and putting it in cough syrup and adding some other things so it tastes okay and it's stable and then packaging it, labeling it, and then advising the patient how to use it safely. You get your prescriptions filled, that's a pharmacist. Pharmacologist, as I described, is usually not a pharmacist, but is usually involved in the research part of developing drugs. And a clinical pharmacologist is usually on the side of selecting and evaluating the effects of drugs.
Okay. Doctor, is toxicology part of pharmacology?
Yes, for human drugs, the study of pharmacology includes the unwanted or untoward or adverse or side effects of the drugs. Pharmacology is the study of drugs, how do drugs work. Most toxic effects are what we call extensions of the desired effect of the drug. It's usually a result of too much of the drug. And any drug indeed can be toxic if enough of it is taken. And so anybody that studies or anybody that teaches pharmacology has to learn about the adverse effects for a number of reasons. Number one, you want to try to avoid them. Number two, if you're a treater and you have a patient come in, you're not sure why they're sick. The first thing you have to do is, if they're taking it, are they taking any drugs? If you know what they're taking, you confirm it, try to rule out the drug effect versus some other cause for their illness.
So that would mean that you teach toxicology as well?
I've taught toxicology principles, and a large part of my consulting practice is evaluation of toxicology reports and testifying and writing reports on the toxicology of drugs involved in cases.
I know you mentioned books that you've authored before. How many books have you authored, and have you authored any research or publications in pharmacology?
I have 6 books that I'm an editor or co-editor of. 5 of them very heavily address adverse effects of drugs and drug development. One is a book that's exclusively addresses the scientific methodologies used for development of drugs. Other publications in pharmacology, I have more than 300 publications in pharmacology. And among those, several dozen book chapters, again, most of them addressing the toxic effects of drugs.
And does the study of pharmacology involve PCP?
Yes.
Have you testified or consulted as an expert in the field of pharmacology and toxicity?
Yes, I am.
And how many times have you consulted?
Testified, pharmacology and drug toxicity in court more than 400 times.
400?
More than 400.
How many times have you consulted?
More than 3,000 in 40 years. Are
these criminal cases, civil cases?
Most of them are civil cases. I would estimate 85 to 90% civil cases. The remaining criminal cases, a lot of the criminal cases include alcohol, but some include other drugs where, for instance, someone might be sleep driving from their Ambien and arrested for DUI, or cocaine found in their body, or marijuana, either use of it or testing positive for it. And I have consulted on some cases involving PCP and testified in at least one trial on PCP. There may be a second.
And in the criminal, well, in all the cases that you mentioned, actually, in the criminal, did you testify for the state or the defense?
In criminal cases, I have testified for the state or prosecutors. I have testified for the defense. Clearly, that's more for the defense. In fact, the majority for the defense.
And were you paid by the defense in this case?
I have been paid Yes,
How much?
I've been paid $10,000 to date. There will be additional billing for my time for preparation for trial and being here today.
Judge, at this time I tender Dr. O'Donnell as an expert in the field of pharmacology and toxicity.
No objection, Your Honor.
I find that Dr. James O'Donnell is an expert in the field of pharmacology and toxicity.
Thank you, Your Honor.
Proceed, please.
Thank you. You were asked by our team to prepare a report opining on PCP and its effects on Laquan McDonald in this case, correct?
Yes,
Did you prepare a report?
I did.
Would it assist you today to view your report as you testify?
It would help me if I have it available if I need it, yes.
Okay, Judge, I asked permission for the doctor to,
Did you consult?
I
with the
did.
state?
yes.
All right, thank you. All right, thank you.
Yes.
All right,
yes,
sir.
no problem.
Thank you, certainly, Dr. You can use the report as necessary.
Thank you.
Thank you. Did you prepare a PowerPoint presentation to assist the jury in learning about PCP and its effects?
I did.
What documents did you review in this case in preparing that PowerPoint and report?
I reviewed several different types of documents, the autopsy and toxicology report for Laquan McDonald, the police reports, some follow-up detective reports, the original video that everybody's seen. I reviewed the ambulance report, EMS report, the Mount Sinai Hospital records. I reviewed reports of Dr. Cheese, reports of Dr. Miller. I've become aware of or read reports of some of the witnesses who testified in the trial so far. And I also reviewed, for purposes of providing references and authorities, several sources of PCP and what PCP is and what PCP does and how PCP does what it does. I think that's.
Did you also review the FBI summary?
The FBI summary, yes, thank you. And I also reviewed some medical history of Laquan McDonald, indicating prescription drugs that he had prescribed for him and what he would have been treated for.
Exit hours. Thank you. What does your PowerPoint consist of?
Well, PowerPoint consists of what I would describe as fact-rich technical information, and listing what I've reviewed, what information I considered in terms of how people at the scene described Laquan McDonald. It also described what PCP or phencyclidine is and what it does, particularly the toxicity. It includes some definitions. It also lays out short descriptions of the opinions that I'm prepared to offer regarding PCP and its effects on Laquan McDonald.
Judge, I'd ask to admit defense 18 into evidence and publish to the jury.
I'm sorry, I didn't hear it. Speak up, please.
I'm sorry. I'd ask to admit defense number 18 into evidence as the PowerPoint of Dr. O'Donnell to assist the jury in understanding his testimony and publish to the jury.
So are you saying you want to use that as demonstrative evidence?
Yes.
All right. Any objections?
Yes, Your Honor, I do object. This is information that does not need to be presented to the jury in the form of a document. The witnesses just testified as to the material that he has reviewed in order to make a decision. So this would be essentially asked and answered for him to repeat it now with a slide show. We don't have a problem with him describing his conclusions, but there is no reason to have those presented in writing to the jury. And Your Honor, description of what other officers did would be hearsay, would not be admissible at all, and certainly would not be appropriate to be visually displayed by this witness.
Defense, are there any quotes by officers in your power play?
Ju-
Right.
Wait, you have a sidebar, please.
Sure.
Thank you.
We need you. Ladies and gentlemen, we're just going to have a very brief recess. Thank you.
All right, for the jury.
Is it demonstrative evidence or what?
Yes.
No, yeah, it's your motion, your exhibit. What is it?
Well, yes, it's demonstrative for identification purposes, Judge.
All right, thank you. All right, it will be admitted in as demonstrative evidence, and the identification marks will be stricken, and you'll be allowed to publish. Proceed.
Thank you.